she's been using the child support reasoning case to get subpoenas to get my wife and my bank
Your
records.
Honor, I object.
All
Well,
right,
she submitted it all
let me
there.
finish.
It's all there. She submitted literally everything that has nothing to do with anything, just to harass myself and my wife.
I object.
Okay. Good morning, sir. Are you John Reading?
Yes, sir, I am. How are you this morning?
We're ready to go. Set that energy drink aside. We'll
Yes,
pretend
sir.
like we're in court and we'll get started. Donna Brown is here with me in the courtroom, and you're here by Zoom, which is acceptable for this first pretrial. Let me call the case. It's 251969GC. It's entitled Donna Marie Brown versus John Paul Reading. We've had some previous cases. We had at least one with these parties in this court. I think there have been some actions in some other courts here. And this is a new general civil case. Plaintiff claims substantial damages. She caps them at $25,000 to keep the matter in the district court. District court has jurisdiction over general civil matters up to $25,000. It's $25,000.01. It must be removed to the circuit court. So am I correct, Ms. Brown? You're capping your request for damages at $25,000.
Yes, Your Honor.
There are multiple claims. I've got, this file is already this back and we haven't even started yet. This morning, I received a pleading from the defendant entitled Defendant's Motion for Summary Judgment to Dismiss for Lack of Subject Matter Jurisdiction under 2.116C4 and 2.116C8. And I haven't had a chance to really review it, and I haven't had a chance to deal with it. And the defendant filed it, but the plaintiff just got a copy when I handed it to her about 2 seconds ago. So we aren't ready to address that matter, but this is a pretrial conference. Defendant is here from his address by Zoom. If we do have testimonial proceedings, he'll need to be here in person. The plaintiff has filed a bunch of stuff, including subpoenas and discovery motions and that sort of thing, some of which may be a little bit premature. The general rule in district court civil matter is there's no absolute right to discovery. And subpoenas don't just get issued willy-nilly. They cause a lot of work at the other end. So, Ms. Brown, you filed this action. You capped.
This isn't just a $25,000 lawsuit. It's the latest chapter in a long-running domestic battle. Former partners, multiple court cases, and now a new general civil claim that may not even belong in this courtroom. The plaintiff says there was a good faith contract for their child's expensive extracurricular activities. The defendant says it was never a contract at all, just a note written to protect state benefits. And hanging over everything is a bigger legal question. Can you take a dispute tied to child support and repackage it as a civil contract claim? Because if this judge agrees with the defense, this case doesn't move forward. It ends before it ever begins.
So, Ms. Brown, you filed this action. You capped it at $25,000. What are you asking me to do here?
Your Honor, I'm looking for relief in this case. There was a contract in good faith between Mr. Redding and I for the children's enrichment, and I have paid for it, and Mr. Redding has stopped paying his contractual obligation. I did just recently submit a motion in to add on exhibits. I tried to follow the process because of the cutoff point, but this information was obtained through some of the other subpoena records in one of my other cases with Mr. Redding, where it does show that Mr. Redding was upholding the contract.
Now, you're talking about this contract. Is that in here?
Yes, Your Honor. Exhibit 1. This was outside of our friend of the court agreements. This is solely in good faith to pay for the lessons and enrichment for our daughter.
And one of the issues is whether this is jumping jurisdiction from the friend of the court to a general civil case. This happens in domestic relations cases. People are unhappy with a ruling in domestic relations. They file a small claims case, or they file a general civil case when the actual jurisdiction lies with the family court. So I can't tell.
This is for extra activities that were quite expensive. It was never part of any of our, it was never even requested in front of the court because it was.
The argument is it should have been, that it should have been part of the front of the court action. It had to do with custody of the children, support of the children, enrichment of the children, and it should have been part of an order. I don't know that that's true, but that's the argument. There's so much stuff in here. I'm looking for the actual exhibit.
Mr. Redding was paying on this in Exhibit 8 that we can see outside of any friend of the court. He was making payments directly to me within this contract.
This contract, Your Honor, that's not a contract, is Exhibit 1. It's just a note. And it's an explanation that she asked me to write to friend of the court. I even write in there, I live in separate units of the house. So I'm not sure why she believes it's contract, but.
Well, I'm trying to even find it. She filed a pleading why this matter belongs in district court, not friend of the court. This is it. To whom it may concern, I verify that I am responsible for Kaylee Redding's dance and horse lessons per our custody arrangements. I pay Donna Brown the cash reimbursement for these activities, also assist with transportation mileage or payment of out-of-pocket expenses associated with John Reading's medical expenses per the custody agreement. Donna is able to pay me bills out of this money. Not sure what that means. We live in separate units of the house and are separated through the courts, taxes, child support in place. Signed John Paul Reading. This document doesn't have a date on it. So she's suing on contract Exhibit 1.
I'm stating, Your Honor, this is a note that she asked me to write to the state because she was on state benefits and she didn't want to be disqualified. Hence the extra explanations in there. This is not a contract.
Defendant contends it is not a contract. But a note to the state.
Your Honor, if we could see Exhibit 8, it can show that Mr. Redding has been paying on this contract, and what he said is not true.
All right, he may have been paying it on a note. Well, so the first question is, it is a contract. Contract has offer, acceptance, an agreement that's only signed by one party. So there's a fundamental question about whether this is even there's several issues. One, should this all be under friend of the court? Two, is this a contract? It's a note to whom it may concern. It's only signed by one party.
This is a good faith, Your Honor, agreement between us with a promise, and I acted based off of this promise and put the money out for our child's activities. And if you could hear this case, Your Honor.
And I will say she knows this belongs with front of the court with anything she's requesting. That's why she even tried to get in front of that before. But in the motion that I filed for judgment to dismiss, I kind of basically put that it lacks proper subject matter. It lacks material terms such as duration, price, payments, lacks clarity and specificity. I mean, it doesn't even have her signature. It's not even a contract. This is literally for her to get state benefits. And she's trying to use it later. She's literally trying to harass me and my wife. The last judgment she sued us me over something that had a $0 balance by the time insurance hit it. She didn't want to provide insurance. So she's been using the child support reasoning case to get subpoenas to get my wife and my bank records.
Your Honor, I object.
All
Well,
right,
she submitted it all
let me
there.
finish.
It's all there. She submitted literally everything that has nothing to do with anything, just to harass myself and my wife.
I object.
Okay,
This is the critical legal moment. The defendant has filed a motion for summary disposition, essentially arguing that even if everything the plaintiff says is true, the case still fails as a matter of law. He's claiming lack of subject matter jurisdiction, arguing that disputes over child-related expenses belong in family court, not district court. He's also attacking the foundation of the lawsuit itself, saying the so-called contract lacks essential elements like mutual signatures and clear terms. If the judge agrees on jurisdiction alone, the district court cannot legally hear the case. That's not a trial loss. That's a procedural shutdown.
well, he disagrees with you. You have a theory of your claim, and he has a different theory. He objects to your claim, and you object to his pleading. Right now, he's filed, very late in the game, a motion to dismiss under summary disposition. If he prevails in that matter, the case is over. If he doesn't prevail, then we can go further ahead. But I can't deal with this because you just got notice 1 minute ago. I don't expect you to come in on the fly and answer his motion for summary disposition. So I'm going to adjourn this for 21 days to give you an opportunity to respond to his motion for summary disposition. And then the second, if we get past summary disposition, there's a fundamental question about whether this is even a contract upon which you can sue. I'm not signing any subpoenas until we get further in this matter. Subpoenas are intrusive. They cause a bunch of work at the other end. They can be a form of harassment. Subpoena this, subpoena that.
Your Honor, the one subpoena was for me against my own employer because of the job loss caused by Mr. Redding and his wife. I know that they had falsely said some things last time in court about her.
Well,
about
I
her
dealt
job,
with some of this at the
but
earlier
this was
hearing.
evidence. That's what I was trying to obtain, actual evidence, not making false accusations as they have. Your Honor, Mr. Redding is very behind in child support, over $14,000, and the subpoenas were. The other subpoena is used to show that he has the means and capacity to pay, but he has not been honest to the courts. And I'm asking.
That's not this case.
Correct.
You can't use a subpoena in this case to prove that he's not paying your child support.
No, this was to show that he had means and capacity to pay.
It's still not this case. It doesn't matter whether he has means and capacity to pay it. That starts if you get a judgment and then you attempt to collect on it.
Yes, Your Honor.
But right now, he filed this last second motion, which isn't fair to you to have to respond to it.
Okay.
So let's continue this.
I clarify, Your Honor, that's only like 5 or 6 months of child support. I mean, I know this is being live streamed, so.
Say that again. I didn't understand you.
This is only about 5 or 6 months of child support, and I've still been making like very low $150, $200 a month payments towards her. It's not like I've not been paying child support for years. It's just for jobs where you're paying almost $2,000 a month in child support. It takes a little bit of time panel interviews.
Yes, this is a child support case that is
Yes, Your Honor.
lapped over into general civil. And that happens, as I said, from time to time. Let's see if we can find a place to put.
If you could, look at Exhibit 8, though, you'll see that he was paying on this separately in this agreement, so.
And I don't, I think that probably is accurate.
Well, if I'm paying on something when we're all living together in the same household, I mean, that's a different
Well,
story.
one
than-
problem is that this thing doesn't have a date on it. I don't know if it's pre-order or post-order or.
Our child support orders were done back in 2015 and 2020. This signature was in 2023 by Mr. Redding. Additionally, with a move out of the house, this was a contract in good faith between us that it was not brought up to friend of the court for any matters because Mr. Redding was paying on these things prior. And
it should have been. You're backdooring the friend of the court by some sort of document that you call a contract. The friend of the court has jurisdiction over child support and these sorts of issues. And you're claiming that outside the knowledge and belief of the friend of the court, that he agreed to this contract. We'll have to figure that out.
Yes, sir.
Today is
She
January
submitted
20.
she submitted all this to the front of the court, and they thought it was unreasonable that I pay $20,000 a year for a child to have a horse and do extravagant activities. If I choose to pay that when I'm living in the house, it has
That's
nothing to do with
correct.
anything here.
Your Honor, this is
Never
never
gone to the friend of the court because Mr. Redding was just paying on it, and that's why I made the decision to keep our child in an activity that was really helping her.
Okay.
All right, finding a place to put this is a little problematic. 21 days would get us into February 16th as a government holiday for President's Day, I believe. I'm gone Monday the 23rd.
Your Honor,
Yes,
if we could, since Mr. Redding and I have multiple things going on, the only way for me to collect is when we sell the house. Mr. Redding has not been paying on the house, and so I'm trying to partition that and push that through with Judge Pattison.
and
So
Judge
any-
Pattison has that case,
Correct. If
yes.
any judgments were to come from this, that would probably be my only window to collect from Mr. Redding. So if the soonest date possible, to try to push this along so that it could go in combination with our other cases, Your Honor.
All right. Well, I can rule on it right now, but you just got it. So I'm adjourning this for your benefit. So
Okay.
I'm trying to find a time to put this. The
Zoom hearing
But we
something
missed
for,
two Mondays in February.
Your Honor, Zoom hearings for the rest of this possibility, as I live in Texas.
Yes, this next hearing will also be by Zoom. I can, but there's already stuff set. The 16th of March is not within 21 days. 16th of February, excuse me, that's a Monday, but we're closed that day. So the next possible day would be the 23rd, and I won't be here that day. So that takes us to March 2nd. Which is crammed full. So I'm going to continue this to March 9th. (2026) at 9:20. You're welcome to come in live or by Zoom. Block 9:20 to 10:30. We'll have more than an hour if we need it. You've got a number of things that you filed, motions, and some of these are not controversial. For example, leave to file supplemental exhibit lists. I won't have a problem if we get that far to allow you to file additional exhibits and witnesses. But the motion that he filed is dispositive. If he prevails, the case is over. And you haven't had a chance to respond to it. So you have 21 days from today to file a response to his motion for summary disposition. You don't have to file a response, but you have a right to. Unfortunately, 21 days would get us to March or February 23rd, which would be a good day, except I'm not here. So the next available space is March 9th at 9:15. He claims lack of subject matter jurisdiction, promissory estoppel, alleges that all child expense disputes should be made with the friend of the court, not the district court, and some other things. So we're on hold pending ruling on those motions. So that's really all we can accomplish. If you have any additional motions you wish to file, notice them out for that same date, March 9th. That's, I guess, all we can accomplish at this point. I've reserved on all the motions that the plaintiff has filed. As I indicated, some of them are not very controversial. Should be easy if we get that far to rule on. But the defendant's motion for summary disposition cannot be heard this morning because the defendant hasn't had a chance to respond. Plaintiff hasn't had a chance to respond. So the entire matter is continued to March 9th at 9:20 a.m. We'll rule further on it. The partition matter is still pending in front of Judge Patterson, is that correct?
So initially I had put that in a petition back in 2024. It went through. Mr. Redding had it dismissed based off of our rights to survivorship. During our personal protection order hearing that I was able to get against Mr. Redding, Judge Patterson told us that it would be best if we changed the deed so then we could repartition. So we agreed to change the deed to remove the rights to survivorship so that I could put it back to petition to get Mr. Redding to sell. Our attorneys were working on that together, and just on Friday at the very end of the day, now Mr. Redding has filed something, even though our attorneys were working together to try to move this forward. So I really don't know.
I do believe at some point that property is going to have to be sold.
It has to be sold. Yes, Your Honor. I've been trying to do that.
For everybody's interest.
Absolutely.
Right now it's just in limbo,
Mr. Redding's not paying on it, and it's really a financial burden to me.
I'm not in that case. I know Judge Patterson would like to get that case over the finish line.
Yes, Your Honor.
Well, in her last request, she wanted me to pay for her and her new husband to live in the house that I co-own, and that's the reason why I didn't. I got part of why I got it thrown out last time, and then she said she was going to file, and then didn't.
All right, I'm not getting dragged into that.
Sure.
Tar ball. I'm going to deal with this. At any rate, the whole thing is adjourned to March 9th, 2026 at 9:20 a.m. You have 21 days to file a response to his motion for summary disposition. And if you have any additional motions you wish to file, you can notice them out for March 9th at 9:30 a.m. I'm not going to rule on any of your other matters until that time. I'm not going to sign any subpoenas or anything further until the pretrial and hearing on motion for summary disposition. All right, Mr. Reading, anything further?
That's all, Your Honor.
All right, Ms. Brown, thank you. I know it was hard to get out today. School's off, freezing cold. You're welcome to be here live every time. You're also welcome to come by Zoom. Mr. Reading, I'm going to excuse you. Ms. Brown, you're free to go. I'll see you on March 9th.
Thank you, Your Honor.
Your Honor.
What unfolded here was not a ruling, but it was a pivotal procedural reset in an already complicated legal conflict. Donna Brown filed a general civil lawsuit against John Paul Reading, claiming up to $25,000 in damages. She alleges that there was a good faith agreement between them requiring him to contribute to their child's extracurricular enrichment, specifically dance and horse lessons. According to her, she relied on that promise, paid for the activities herself, and now seeks reimbursement because he stopped paying. The entire case hinges on a single written document. The plaintiff presents it as a contract. The defendant calls it something entirely different, a note written to whom it may concern, allegedly drafted so she could maintain state benefits. The document is signed only by him. It lacks a date. It contains informal language and references to custody arrangements, but does not clearly define duration, payment terms, or enforcement language. Legally, a contract requires offer, acceptance, and mutual agreement, and typically clarity in terms. The judge immediately recognized that threshold issue. If the document is not legally enforceable as a contract, the claim fails regardless of any payments previously made. Past voluntary payments do not automatically create a binding legal obligation. But even more significant than the contract debate is the jurisdictional fight. The defendant argues that this entire dispute belongs in family court, specifically under the authority of the friend of the court, which oversees custody and child support matters. The judge openly acknowledged that sometimes litigants attempt to reframe domestic disputes as civil claims. If this enrichment expense should have been addressed during child support proceedings, then district court may not have authority to hear it all. That's why the defendant's motion for summary disposition is so important. If the court finds that it lacks subject matter jurisdiction, the case ends immediately. No subpoenas, no discovery, no trial, just dismissal. The judge made clear that he cannot even consider the plaintiff's additional filings until that threshold question is resolved. We also heard broader context: ongoing child support arrears, disputes over the jointly owned home, and a pending petition matter before another judge. But importantly, the judge separated those issues from this case. He refused to allow subpoenas aimed at proving child support nonpayment, because that is not the issue before this court. That distinction matters. Courts operate within defined boundaries, and this judge reinforced those boundaries repeatedly. Ultimately, the hearing concluded with an adjournment. The plaintiff now has 21 days to formally respond to the motion for summary disposition. A Zoom hearing is scheduled for March 9th, 2026. On that date, the court will determine whether this case proceeds, or whether it stops on procedural grounds. This case highlights a recurring legal tension. When personal disputes overlap multiple court systems, choosing the right venue can determine the outcome before facts are ever tried. Contract law and family law operate differently, with different standards and remedies. Whether this was truly a private contractual promise or an issue that should have been handled through child support modification is now the central question. And here's the key question for you. Should agreements between former partners about child expenses be enforced as private contracts, or strictly handled through family court oversight? If you found this breakdown helpful, make sure to like the video, subscribe for more courtroom analysis, and share your thoughts in the comments.